Welcome to my channel. Please like, comment, and subscribe. The purpose of maritime law is to govern private, international, and domestic nautical matters. More specifically, these laws protect maritime workers who have sustained injuries and allow them to claim damages and certain benefits. We examine the different types of maritime laws, how they protect maritime workers, and where to find an offshore injury lawyer if you have been injured on the job. The Longshore and Harbor Workers Compensation Act. This program compensates maritime workers who have become injured while working on or near navigable waters. Specific locations covered by this act include cargo vessel loading and unloading areas, pier and deck work sites, and ship repair space. Any worker, whether employed as a shipbreaker, harbor worker, recreational vessel worker, or office and retail employee, is covered under this act. However, employees eligible for state compensation or benefits are excluded from coverage under the act. Those who wish to make a claim under the Longshore and Harbor Workers Compensation Act have 1 year from their date of their injury to do so. But the statute of limitation can also begin after an employer stops paying compensations and benefits. However, those who qualify for compensation under this act are advised to file a formal claim within the 1 year time limit, even if they are being paid by their employer while injured. The injuries commonly covered under this act include permanent disability, death, and loss of organs or limbs. Compensation for injuries continues for as long as an injured worker is recovering, and it is paid each week. Employees receive just over 66% of their weekly wages. And then, maintenance and cure. For maritime workers, this particular law offers protection in the event of illness or injury sustained while on the job, no matter who was at fault or how the accident occurred. Another important aspect of this law is that it provides injured workers, whose employer's compensation may not be enough, with sufficient funds to survive and pay their expenses. Maintenance and cure is a general maritime law that states that maritime workers are entitled to be compensated for their expenses in terms of maintenance, daily living expenses, including food, clothing, and shelter, and then cure, any medical expenses related to the injury sustained. The maintenance portion of the law provides injured maritime workers with compensation until they have achieved medical recovery. However, this compensation extends only to necessaries required for daily life, not luxury items like internet connectivity or entertainment. The cure portion of the law mandates that employers are responsible for the payment of any and all medical expenses associated with an employee's injury. These expenses can range from doctor and hospital bills to prescriptions and CT scans and surgery, to transportation to and from doctor appointments, to needed medical equipment like crutches. Although this portion of maritime law is meant to help maritime workers with their medical expenses until such time as they have reached full recovery and or can return to work, some employers try to avoid payment by rushing the process and causing workers to resume working before they are fully recovered. And the next is Death on the High Seas Act. The Death on the High Seas Act provides compensation to families of maritime workers who perished on a vessel at a distance of 3 or more nautical miles from shore. Enacted in 1920, the Death on the High Seas Act now provides compensation for monetary losses as well as death for mental injuries and trauma associated with the loss of a family member. As well, it was amended in 2000 to include compensation for aircraft incidents that claim these workers' lives. Getting compensation under the Death on the High Seas Act can be a highly complex process, as the amount awarded in compensation is determined by calculating the amount of loss incurred without the income of the deceased maritime worker. The vessels covered under this act include cruise ships, ferries, tour boats, oil rigs, and commercial fishing boats. Distance from shore is only one of two factors under which a family can be compensated under this act. The death of a loved one while at sea must either be recognized as wrongful, neglectful, or a result of default, and the charge laid as such. Each maritime personal injury case is individual, and a wide range of negligence can be alleged. For example, an employer may not have provided proper medical training or may have failed to provide sufficient medical care to the deceased employee. A vessel may have overturned or experienced an explosion that caused an employee's death. Unfortunately, shipping companies have attempted to avoid taking mandatory responsibility for families of deceased seafarers by attempting to use the Death on the High Seas Act to their advantage. And the next is the Jones Act. The Jones Act is a federal law that provides seamen or individuals engaged or employed in any capacity on board a vessel with compensation for their injuries while on the job. It addresses issues related to the transport of goods or people between ports in the same country and maritime commerce. It also protects sailors from being exploited by employers. Under the Jones Act, an employer must maintain a safe environment for their employees and provide them with medical care. It also includes standards for the maintenance of vessel and safety equipment, as well as licensing, training, and qualification that crews must meet. This act, like the Death on the High Seas Act, requires proof that another party's negligence caused these injuries. Seafaring employees have 3 years from the date of their injury to file a lawsuit. If this does not occur, their case can be dismissed. Common charge filed under the Jones Act range from the unseaworthiness of equipment masters, crew, or the vessel itself to punitive damages and wrongful death. In order to qualify as a seaman under the Jones Act, an employee must spend no less than 30% of their time on board the vessel on which they work. But this amount is not absolute. A Jones Act attorney is the best person to consult if you feel you may qualify for compensation. Thank you very much for watching. Don't forget to always give your like, comment, and subscribe. And see you in the other video.